Please, Your Lordship. Your Lordship, beg to mention item number 5, Your Lordship. I pray if Your Lordship can have this matter after 2 weeks, Your Lordship.
Why?
Conducting counsel is on leave, Your Lordship.
It's a long pending matter.
No objection, Your Lordship.
On pre-meet by the petitioner, this is matter 2 weeks.
Deeply obliged.
Obliged, Your Lordship.
From supplementary list, item number 1.
Pleasure. It's a my lord anticipatory bail application, my lord. The petitioner is a my lord registered owner of a truck vehicle, my lord. And from the truck vehicle of the petitioner, my lord, 242.51 kg of ganja was recovered, my lord, along with 600 bags of cement. And accordingly, my lord, the truck was seized and the driver was arrested, my lord. Although, my lord, the driver was arrested, my lord, subsequently, my lord, immediately the driver was, my lord, released on bail, my lord. Here, my lord, section charge, my lord. Section 8C 20B 2C 25(9) of the NDPS Act, my lord. So at this stage, my lord, since my lord commercial quantity is involved, my lord, may I paid for my lord call for the CD, my lord, and fixing a date after 10 days, my lord.
Why CD? What are the papers you have annexed?
Lordship, my lord.
What are the papers you have annexed here?
Here, my lord, FIR, first of all, my lord, page 10 is the, my lord, document of my vehicle, my lord, 10, 11 and 12, my lord. Page 10 is the, my lord, temporary authorization of registration certificate, my lord. Here, my lord, third line from, second line from bottom, my lord, honor, Mr. Saurabh Saha is the petitioner before your lordship, my lord. And page 11, my lord, it's a, my lord, insurance policy, my lord, package policy. And page 12, my lord, it's a, my lord, certificate of fitness, my lord. And page 13 onwards, my lord, it's FIR, my lord. It's a long FIR, my lord.
You are not denying that the vehicle belongs to you.
Lordship, my lord. I'm since, my lord, I am the registered owner of the vehicle, my lord. I am apprehending arrest in this case, my lord. Otherwise, my lord, in the FIR, my lord, nowhere, my lord, it was alleged that, my lord, I am involved in this case, my lord. And more particularly, my lord, the driver of the vehicle, my lord, he admitted that, my lord, he, my lord, transported those items, my lord.
Where is his statement?
Page 16 and page 21. Page 16, kindly see, my lord.
16.
Page 16, paragraph number Roman 5. Thereafter, at around 10 hours on the same day, the DRI officer started removing the truck bearing registration number such and such in presence of 2 independent witnesses and in the presence of the said Sri Kuldeep Singh, driver of the truck bearing registration number such and such. The driver then called some labor to unload the 600 bags of cement from the said truck. Thereafter, all the 600 bags of cement were unloaded from the truck. After the unloading all the bags of cement, the DRI officer, while closely inspecting the steel floor of the cargo bay of the said truck, observed some abnormality in the welding and at the joint of the rectangular sheet of steel flooring in the middle of the cargo bay, which the officer showed to the independent witnesses and informed them about his suspicion of contraband good being concealed under the steel flooring of the cargo bay. Then, in presence of 2 independent witnesses, the DRI officer asked Sri Kuldeep Singh, the driver, whether there was any cavity under the steel flooring of the truck and whether any contraband goods ganja were concealed therein, to which Sri Kuldeep Singh admitted that 58 rectangular brown adhesive tape wrap package containing compressed ganja have been concealed by him in the specially made cavity under the steel flooring of the cargo bay of the truck. And now, my lord, kindly turn to, my lord, page 21, my lord. Page 21, Roman 12, my lord.
Yes.
Your Honor, in order to find out a specific role played by the apprehended person and to know about other persons involved in the illegal trade of narcotic drugs, the statement of Sri Kuldeep Singh was recorded on 18/12/2024 under section 67 of the NDPS Act 1985. Wherein Sri Kuldeep Singh confessed his active and conscious involvement in the seized ganja in the instant case, my lord. And now, my lord, kindly see, my lord, page 24, the bail order of the Kuldeep Singh, my lord, page 24, my lord. At the time of my lord seizing the articles, my lord, he was taken into custody, my lord. Page 24, it's start, my lord, and relevant portion, your lordship will find at page 30, my lord. Page 30 is the relevant. In the fact and circumstance of the incident case, there has been clear violation of Article 22 of the here, my lord. What happened, my lord? He was not produced within 4 hours from his, my lord, detention, my lord. Therefore, my lord, he was, my lord, released on, my lord, prior bond, my lord. In the fact and circumstance of the incident case, there has been clear violation of Article 22 of the Constitution of India, and I am of the considerate view that accused is entitled to be set at liberty on ground of being under illegal detention of the DRI. Accused Kuldeep Singh is hereby released on PR bond of sum of rupees 1 lakh on the following terms and conditions, my lord. And accordingly, my lord, page 31, my lord, he has submitted the PR bond and, my lord, enlarged on bail, my lord.
Yes.
Your Lordship, this case relates to seizure of 252 kgs of ganja, Your Lordship, from a truck which was intercepted at Mauringkanang area. And the ganja was recovered from a secret cavity which was constructed on the floor of the entire truck. And the petitioner before Your Lordship is the owner of the truck, Your Lordship. So they are contending that they were not aware of the secret cavity and what ganja and what the truck was carrying. So, Your Lordship, what they have done, firstly, Your Lordship, the person who was found in possession, the driver, he was released on PR bond by the learned trial court. And after his release, he has absconded, Your Lordship. Now he is nowhere to be found and the matter is still under investigation. The date of arrest is 17th of December 2024. The period of investigation is 6 months as per the Act, the default period, Your Lordship. But after he was released, he is now nowhere to be found. Notice has been issued, warrant has been issued. He cannot be found anywhere. Now, in a national newspaper and a Delhi newspaper, the notice has also been published by the learned trial court's direction, Your Lordship. Still, he is nowhere to be found, and the investigation has come to a stall. Now, during investigation, it was found, Your Lordship, that this person, the petitioner herein, he is the registered owner of the truck, so summons were issued to him. First, summon was issued to him, he was not found in his address. They told that he has gone somewhere, they locked the door. So it was pasted on his wall. He did not appear on the relevant date. A second summon was issued, Your Lordship. Still he did not appear. Thereafter, in the month of January 27th, he filed a petition for anticipatory bail before the learned trial court, learned court below, Your Lordship, stating the same grounds wherein 15 days interim was allowed to him and on certain conditions. Thereafter, Your Lordship, after 15 days when he appeared, he violated the conditions of the interim anticipatory bail, and as such, his anticipatory bail was rejected.
What are the conditions that he has violated?
I just Lordship, order dated 27/1/25 is the order of the interim anticipatory bail. The conditions are at the second last page.
Yes.
Your Lordship, that he shall appear before the IO within 48 hours. Thereafter, as and when called for, he shall cooperate with the investigation and shall not make any inducement, threat or promise to any other witnesses acquainted with the facts of the case, that he shall not hamper or tamper with the investigation, that he shall be present in court at the time of final hearing. These were the conditions, Your Lordship. So, the conditions were violated by him. He did not appear within 48 hours before the investigating agency for recording his statement. Thereafter, Your Lordship, before the final hearing, before his anticipatory bail was rejected, he appeared before the investigating agency. His statement was recorded, but it was not in compliance of the court's order. He came on his own time whenever he pleased, Your Lordship. And in his statement, he is
What do you
trying.
mean? What do you mean? He came in his own time whenever
He
please?
did not appear within 48 hours, Your Lordship.
Oh,
He
within
came
48.
after several dates, Your Lordship. And he did not even cooperate with the investigation. He's trying to mislead the investigation, Your Lordship.
Okay.
Your Lordship, in his statement, Your Lordship, if Your Lordship kindly takes the other order, Your Lordship, 13/2/2025,
Yes.
the third last page, Your Lordship. His statement is Your Lordship, fourth last page, Your Lordship.
Yes.
Your Lordship, number A, Roman A. He himself admitted that he received the 2 numbers of summons notice from DRI. He is admitting that he is registered owner of the seized 14-wheeler vehicle. He purchased the said truck amounting to rupees 39,85,000 and the truck was financed by so and so. After purchase, the truck was sent to Punjab by him for construction of body through his reliable truck driver Kuldeep Singh. He spent an amount of 6,25,000 for construction of the body. Further, he stated he do not know the name and any other details of the truck body maker. An amount of 2,25,000 was paid in cash and the remaining was paid through UPI to Kuldeep Singh. He did not obtain any voucher, bill, invoice, cash memo from the body maker. He stated in the month of June 24, the truck arrived at Agartala after body making. He himself inspected the body and floor of the truck and he was satisfied with the work. Next page, Your Lordship. He stated that his driver Kuldeep Singh had constructed the secret cavity, he is admitting, Your Lordship, in the cargo bay of the truck in the month of May 24. After purchasing of the truck, his driver advised him to construct the body of the truck in Punjab as it is cheaper and the quality of the work is good. So he agreed to him and handed over the vehicle to the driver. After the completion of construction of the body of the truck, the said truck arrived at Agartala and so date. The body and floor of the truck was constructed as per his choice and he was satisfied with the work done. He is admitting that it was done as per his choice, Your Lordship, and the secret cavity was also constructed. Shri Saurabh Saha is the registered owner of the seized truck bearing so and so. After purchase, the said truck was not registered in Tripura, but the said truck was registered in Nagaland intentionally. He sent the truck for body making in Punjab, and after body making, he was satisfied with the work which was done by the body makers. He could not provide any documents on name, address, and contact number of body makers where his truck's
This is
body
not
was
relevant.
made.
Let's go to the relevant portion.
Your Lordship, the relevant portion is at the next page, Your Lordship. The court's operative part of the order, Your Lordship. I have perused the objections filed by the DRI. The petitioner has also produced printed copy of the transactions made by him to accuse Kuldeep Singh. However, these transactions submitted do not establish or prove the innocence of the petitioner. There is no clarity as to for what purpose the payments were made to Kuldeep Singh. The petitioner although submits that the payments were made for making of the body of the truck, however, there is no such record to show that the payments were made for the body making. It is also surprising that the petitioner, being a owner of the new truck valued at 47,75,000, does not know the name and address and contact number of body maker, and that he simply gave 6,25,000 only to the body maker. He himself inspected the whole body of the truck after the body making, and having been satisfied, it appears that he is now trying to shift all the responsibilities to his reliable driver Kuldeep Singh. As per the DRI report, Shri Saurabh Saha intentionally, deliberately has not disclosed the name and address of the body maker. He did not register the truck in Tripura, he registered the same in Nagaland, and the body of the truck is also not made in Tripura. But he sent the truck to Punjab for making of the floor and the body. His intention clearly proves that he himself has given the order to the body maker to construct a secret cavity on the floor of the cargo bay. There is no explanation to this report of the DRI from the side of the accused. This casts doubt on the conduct of the petitioner, and there are reasonable grounds for believing that he was aware of the construction of a secret cavity in the truck, and the same was constructed for the purpose of committing the instant offence. In view thereof, this court is not inclined to extend the interim pre-arrest bail granted to the petitioner. Hence, this pre-arrest bail is rejected. Lordship, the learned trial court below has also made an observation. Since being the owner of the truck, what his truck is carrying, he may not have been in physical possession, but he is in constructive possession of his truck, and without his knowledge, how a secret cavity can be constructed in the entire body of the truck, Your Lordship. And in his statement also, he is not disclosing.
Yes, sir. Where is your averment? Averment that you are not aware of the
Lordship, my lord.
activities of your
Prior to this, my lord, prior to that, my lord, I want to, my lord, reply to the, my lord, violation of the interim order, my lord. It's, my lord, page 41, my lord, entire reflecting, my lord. It was 48 hours time was granted to me to appear before the, my lord, IO, my lord. The order was passed on 27/1/2025, my lord. The petitioner is hailing from, my lord, Tripura, my lord. From Tripura to Guwahati, it took, my lord, 15 hours, my lord, in train, my lord. And thereafter, my lord, from Guwahati to, my lord, Shillong, my lord, another some hours is required, my lord. Therefore, my lord, on 48 hours, my lord, it was impossible on my part to appear before the IO, but, my lord, on 31/1/2025, my lord, immediately, my lord. 27, my lord, order was passed, and 31/1, my lord, I appeared before the IO, my lord. So there was some delay in hours, my lord, not, my lord, like, my lord, weeks or, my lord, days, my lord. Therefore, my lord, that part I have replied, my lord. And so far, my lord, my conscious possession, my lord, I have page 32, may kindly see, my lord. First annexure, my lord. Thereafter, I will go to the environment, my lord. Page 32, my lord. It's a commercial vehicle, my lord. Page 32, it's an authorization letter, my lord. Through my driver, my lord, I have been playing this vehicle, my lord. Through this authorization letter, my lord, I have been playing, my lord. And, my lord, now, my lord, kindly, my lord, peruse my petition, my lord. Paragraph 5 and 6, my lord. Paragraph 5, my lord. That the petitioner states that the petitioner is the owner of the truck being raised. There is no, I'm not, never, my lord, disputed that I'm not the owner, my lord. Every time I am, my lord, admitting, my lord, I am the owner, my lord. Owner of the truck being registered under such and such, and the petitioner has been playing the aforesaid truck vehicle through his driver Kuldeep Singh on hired basis, and for effective and smooth running of the said vehicle on hired basis, an authorization letter dated such and such was executed between the petitioner and Shri Kuldeep Singh before the notary public, Tripura. And in the said authorization letter, it is specifically mentioned that Kuldeep Singh will drive the vehicle of the petitioner as he hold an effective driving license bearing number such and such, and Kuldeep Singh will drive and look after the vehicle of the petitioner until further authorization to any other driver. And in the authorization letter, it is further mentioned that Shri Kuldeep Singh shall bear all the responsibility for damage and stolen expenses thereto, and the validity of the authorization letter till 21/5/2026, my lord. So all along, my lord, it was, my lord, it was my the truck was, my lord, applied by the driver, my lord. And being a owner, my lord, it's not possible to any time, my lord, to look after the vehicle, my lord, where, my lord, such a, my lord, truck is concerned, my lord. And so far, my lord, issuance of, my lord, summon to the petitioner is concerned, my lord. Yes, my lord, I have received, my lord. But, my lord, since the case is, my lord, non-valuable in nature, my lord, the apprehense, my lord, on the date of appearance, my lord, I may be taken into custody, my lord. Therefore, my lord, if some protection granted, my lord, I will appear, my lord, I will cooperate.
Or Mr. Mayor Counsel for the petitioner, who has submitted that this is an application under section 482 of the BNSS with a prayer for grant of pre-arrest bail. The apprehension of the petitioner relates to a change of events which involves his vehicle bearing number, his vehicle being a commercial truck bearing number NL01AH80847, driven by Shri Kuldip Singh, the driver of the said truck, the authorized driver of the said truck. It is the submission of the learned counsel that records would show that on 17/12/2024 at about 6:30 a.m. or so, the said vehicle, while flying through the state of Meghalaya, was intercepted by the DRI officials at, where was it intercepted?
It was my lord, on
Which place actually?
on 17 my lord, on the date of FIR my lord, page 13 my lord, is FIR my lord. It was intercepted on 17 my lord.
Intercepted on?
17 12 2024.
Yeah, 17. That's what.
Lordship.
But where was it?
Mountain.
Morning. At Morning on the National Highway itu. Check to the highway day at Moroccan, wherein it was found that the vehicle was loaded with 600 bags of cement. However, on closer inspection of the said vehicle, there was found a secret compartment below on the flooring, steel flooring of the cargo bay, where, on being pried open, 58 packages containing ganja, under bracket cannabis, and other materials was discovered. The quantity of the seized, the recovered ganja is 242.510 kg. Accordingly, a case was registered under the relevant provision of the NDPS Act, and the said driver was arrested by the police. However, in due course, the said driver was later granted bail by the Court of the Learned Special Judge and NDPS Law. The case of the petitioner is that the said vehicle was the said vehicle, though it belonged to him, was under authorization handed over to the care and custody of the said driver, who is at liberty to apply the same and to make use of it, make use of the said vehicle for business purposes. The petitioner has no knowledge of the cargo or goods ferried in the said vehicle, and as such he submits that as submitted by the learned counsel, he cannot be implicated in the said case. However, since it is admitted that the said vehicle belongs to him, in apprehending, arrest, he had approached the learned court of the court of the learned special judge, NDPS, with prayer for grant of anticipatory bail, for which by the relevant order dated 27/1/2025, interim bail was granted to him with conditions set therein. However, when his application was taken up for final consideration, the learned special judge by order dated 13/2/2025 had dismissed the same. Hence this petition. Next, the learned counsel has further submitted that the petitioner would maintain that he has no knowledge whatsoever of the activities of the said driver, who allegedly had admitted before the authorities concerned that the said seized contraband substance, advocate ganja, was concealed by him in the said cargo bay of the truck. Under such circumstances, it is prayed that the petitioner will be allowed to be enlarged on bail in the event of his arrest, with any condition as deemed fit and proper to be imposed by this court. In the meantime, before final disposal of this instant petition, it is the prayer of the petitioner that he may be allowed to go on interim bail, to allow this court to call for the case record to enable it to produce the materials therein. Per contra, Mr. Learned Counsel for the appearing for the respondent, Union of India, has strongly opposed the preamite on the ground that you want to add anything else?
Lordship, my lord.
You want to add anything else apart from what I've dictated? Apart from what I have dictated,
Lordship, I
you
have
want to add any point?
no, that will be sufficient, my lord. And I want to highlight, my lord, page 21, which I have already seen to your lordship, my lord. When Kuldeep Singh, the driver, has confessed his activities and conscious involvement in the seized article, my lord. Page 21.
That has been noted.
Lordship, my lord. Yes.
That has been noted that he has
Lordship.
confessed that he
Lordship,
he has concealed.
Lordship, my lord.
Kunuto. Firstly, the fact that the said truck belonged to the petitioner is not denied, and as to how the truck was how the body of the truck was constructed, including the provision for construction of the said secret cargo bay, records would show that the petitioner is aware of the same, and as such inference can be drawn to say that the petitioner is in the know as to what would be the purpose for which the truck is to be used, apart from ferrying of the normal materials like cement, etc. The other point raised by the Learned Counsel is that the petitioner, on being granted interim bail by the said order dated 27/1/2025, one of the conditions set by the court granting him interim bail is that he should appear for the IO concerned within 48 hours which he failed to do so and has appeared before the IO only on the 31st,
31/1/2025, my lord.
31
1/2025, my lord. At 12:15 hours.
This by itself would indicate that the petitioner has violated the conditions set forth and therefore cannot come before this court praying for leniency. What are the points you've urged?
Yes, Your Lordship. Your Lordship, the other point is that the learned court below has also observed that he has made a payment during investigation we have found of 6,25,000 rupees, 25,000 rupees to the driver. But there is no clarity for what purpose the payments were made, Your Lordship.
What does that got to do with these?
Then he will be covered under
is the-
27A, Your
No,
Lordship.
is the payment, linked to the, that the alleged,
Contraband, yes, Your
contraband?
Lordship. Because as per my instructions from the IO, Your Lordship, he has been financing this illicit trafficking. Before they were carrying fancy dial, now they are doing ganja. He has previous criminal antecedents.
Nothing is there on record.
So, Your Lord, it's still under investigation, Your Lordship.
Still, there is no doubt. But that
But he
is,
could not clarify why he
nothing.
made the payments.
you have not brought any materials in that regard.
And another point, Your Lordship, that he is a resident of Tripura. He constructed the body at Punjab. He registered the vehicle at Nagaland. This is
Is there any bar for
there is no
anybody
bar, Your
to do?
Lordship, but this shows his criminal.
If you have a vehicle and get it, modified in Delhi, then what do we do? What do we say?
Yes,
That you have ulterior motive.
but a secret cavity was found in
That is a different thing. That has been noted.
Yes, Your Lordship. These are my grounds, Your Lordship.
It is further submission of the learned counsel that the driver of the said vehicle, on being enlarged on bail, has absconded and could not be traced out, thereby putting the brakes on the ongoing investigation. And if the petitioner, who is probably in the know of what is going on, is allowed to go on bail, the fact that he is a permanent resident of Tripura, there is no guarantee that he may not be, that there's no guarantee that he would cooperate with the investigation, or that he would appear before the IO as and when required. It is therefore prayed that this petition will be dismissed as devoid of merits. This court has heard the parties and have gone through the petition in hand, including the said order dated 27/1/2025 and the order dated 13/2/2025, passed by the learned special judge NDPS Shillong, copies of which have been produced before this court today. Apparently, next, the quantity of seizure of the contraband substance, ganja, constitute commercial quantity, and as such, with regard to grant of bail, this court would have to look into this, into this petition through the prism of section 37 of the NDPS Act. Needless to say, the said provision has highlighted two principles contrary to the popular principle of bail jurisprudence, that is, under quote, bail and not jail, where under the said provision the principle is applied to the contrary, that is, jail and not bail. And if bail is to be granted, firstly, the court is to be convinced on reasonable grounds that the accused, petitioner, applicant is innocent, and that he shall not commit any similar offence or offences if enlarged on bail. Next, the facts of this case would reveal that the said contraband substance was seized from the truck belonging to the petitioner, though driven by another person. The petitioner has not been able to explain as to his ignorance, if at all, of the said secret compartment or cargo bay located within the said truck. It is therefore to be presumed that he is aware of the presence of such a cargo or secret compartment. Secondly, the contention of the learned counsel for the respondent that the petitioner, being a permanent resident of another state apart from the state of Meghalaya, the criminal case being instituted within the state of Meghalaya, therefore he in all probability would be a flight risk if enlarged on bail. In any view of the matter, this court is not convinced by the submission of by the prayer made by the petitioner. Accordingly, this petition is hereby dismissed as devoid of merit. Dispose of accordingly. Value.
Item number 2.
May it please your lordship. This is also an NDPS case, lordship. Here, the accused was arrested, lordship, on 9th of March 2024, lordship, on the allegation that some contraband were recovered from the residence of the accused person. That is Rangshakona, falls under River District, Lordship. Now my lord will find the affair at page 8, Lordship. Page 8.
Yes.
May I read, Lordship? This was addressed to Nongpo Police Station, Lordship. Sir, with reference to the subject cited above, I am to inform you that on 8/3/2024 at around 10 p.m. received credible source information that a drug peddler by the name of Kaisi Kamo had collected a consignment of illegal contraband from Dimapur, Nagaland, on behalf of a lady drug supplier by the name of R. Gracie Hravenai, and kept at his house at Rangshakona, 15-mile Burnihat. Further information was also received that the intended receiver of the consignment is a person by the name of Tilok Rai from Shillong. Accordingly, on receipt of the information, self along with the team of Burnihat OP proceeded towards Rangshakona on Rangshakona 15-mile Burnihat, and through other source revealed that the above noted person is staying at the house of one Srimati Jeni T. Sangma, wife of the accused. Later, the independent witnesses called on the spot, and on arrival of Sri B. Jarwa, MPS, Additional SP Nongpo NDPS, procedure were followed, and accordingly authorization was given for body search. A notice under Section 50 NDPS Act was given to the above said person, and he agreed to be searched in the presence of GO. Accordingly, body was searched and conducted on the spot in the presence of independent witnesses, and on conducting house search of the aforesaid person, 8 soft boxes containing suspected yellow-orange powder packed in transparent polythene bag were recovered, which was kept concealed in a pink plastic bag. Accordingly, preliminary test was conducted at the spot in the presence of available witnesses using the drug testing kit on all the 8 yellow-orange powder packed in transparent polythene bag, and the tests were positive for heroin. The weight and measurement of the contraband was conducted with the help of electrical weighing machine, and in course of weighing, the weight of the contrabands were packed in white polythene bag, in which one number white polythene bag was found weighing 1 gram, and the net weight of contraband is 92.442 grams. Accordingly, the contrabands were packed and sealed at the PO, then were seized accordingly in presence of the witnesses, and the accused person were taken into custody. Based on the allegation, I was taken custody on the same day, Lordship. Now, after that, Lordship, then charge sheet was filed. The case was registered, Lordship, under Section 21B, 27A, and 29 of NDPS Act, Lordship.
Yes.
Now, Lordship, after that, on 174 or 75 day,
Yes.
just few days before the expiry of the statutory period, the police filed the charge sheet.
Yes.
Now, Lordship, I have enclosed the abstract of the charge sheet. The charge sheet is almost 200 pages, Lordship. The relevant part, Lordship, will find at page 25, Lordship.
Yes.
Page 25, Lordship. Under the above facts and circumstances, a prima facie case under Section 21B of NDPS case has been found well established against the arrested accused person Sri Kaisi Kamo, 36, son of so-and-so, Rangshakona, 15-mile Burnihat, so-and-so, Nagaland, for transporting, importing the contraband from Dimapur, Nagaland to Meghalaya, and Section 27A/29 of NDPS Act against Sri Tilok Rai, so-and-so, resident of so-and-so East Kashil district, and Srimati R. Gracie Hravenai, wife of so-and-so, for conspiracy financing the accused person, Sri Kaisi Kamo. Now, Lordship, here the accused person has been charged under section 21B, Lordship. Now, 21B, Lordship, if my Lord will find 37, Lordship, 37, even 27 also falls. The rigor of section 37 will be applicable in section 37A also. My Lord, Lordship, A for a offence punishable under this act shall be cognizable. Now B, Lordship, no person accused of an offence punishable for offences under section 19 or section 24 or section 27A.
You're reading?
37B, Lordship.
Yes.
B, Lordship.
Yes.
No person accused of an offence punishable for offence under section 19 or section 24 or section 27A, and also for offences involving commercial quantity, shall be released on bail or on his bond unless the public prosecutor has been given opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court satisfied that there are reasonable grounds for believing that he is not guilty of such offence and he is not likely to commit any offence while on bail. The limitation on granting of bail specified in clause B of subsection 1 are in addition to the limitation under the Code of Criminal Procedure Code of so-and-so or any other law for the time being enforced on granting bail. Now, Lordship, this case is charged against the accused person, that is section 21B, Lordship. That is intermediate quantity, and the rigor of section 37B will not be applicable. In this case, Lordship, the general principle of law my Lord just now has dictated, that is the bail is the rule and the jail is the exception. That will be applicable in this instant case, Lordship. Now, Lordship, another aspect, Lordship. Now, although the case was registered under section 27, now because of that, Lordship, I could not avail the statutory bail, Lordship, because the intermediate quantity, the time period for intermediate statutory period is 60 days, Lordship. 60 days. Now, Lordship, I went, but since the case was not charged sheeted, so I could not avail that rights also, Lordship. Now here, Lordship, they have been, the accused.
The charge sheet was filed before the 60th day.
No, Lordship, 70 or 70, altogether 174 days, Lordship. My Lord will find.
But 21B would stipulate only 60.
Only 60 days, Lordship.
Then you could have will.
My Lord, since there was no charge sheet, Lordship, now that since the case was charge sheeted, this case was registered under 27A, Lordship.
What is the section is cited in the FIR?
My Lord will.
After FIR was 27A.
Yes, Lordship. Lordship will find in the
29.
FIR itself, Lordship. That is at page 8, Lordship.
Okay, it's okay. So when you were charge sheeted, the IO has proposed only 21B.
Yes, Lordship.
Charges have been framed?
No, Lordship. Now it has been more than 1 year, Lordship.
1 year?
Yeah, more than 1 year. I was arrested on.
After 1 year after the charge sheet has been filed?
No, Lordship. Charge sheet was filed on September last year, Lordship. Now the accused has been inside the jail for more than 1 year, Lordship. Almost 1 year and going to be 1 month, Lordship. So, my Lord, here there is a prolonged delay. And moreover, there is the intermediate quantity. My Lord have passed many judgment, Lordship. I am not repeating all those things for the sake of argument, Lordship. Now, here, Lordship, that there are 15 witnesses, Lordship. There is no likelihood that the trial will be concluded within a near future, Lordship. It will take time, Lordship. The charge has not been framed. 15 witnesses, Lordship, will ever that very difficult to, once the case is charged, very difficult to find out the witnesses also, and it will go on, Lordship. So what I pray, Lordship, since his custody is not recorded at this stage, only the thing is that whether only to secure his presence so that he cannot defeat the process of the trial, that any strict condition, Lordship, any strict condition to secure his presence is ready to.
Yes, Mr. Guru.
My lord, in this case, I have got threefold objections, my lord. Firstly, the technical. Secondly, the factual. Thirdly, the legal part, my lord.
Yes.
Why technical, lordship? This petition has been preferred before this honorable court, the highest court in the state, my lord. At least some minimum standard has to be maintained, my lord. Kindly come to, my lord. Kindly come to page 5, paragraph 11, my lord. If I may read.
Yes.
That this is the first bail application before this honorable court. No bail application was rejected by the learned court below or by this honorable court, and no other bail application is pending before any other court. Now, my lord, on 26/11/2024, my lord, bail was rejected by the trial court below, my lord. So this is a false bail. This is misleading. Secondly, my lord, the technical objection is there, my lord. Kindly come to page 4. There are 7, my lord.
Yes.
Now here, the bail is being moved on behalf of the accused, who is a man, a male, my lord. Kindly, the petitioner is, as stated earlier, that the accused has been languishing in jail ever since her arrest. No, my lord, this undermines the very, my lord, the standard practice before the High Court. My lord, there are lots of juniors, they have to at least learn, my lord. That is my technical, my lord. I am coming to the factual aspects, my lord. So actually on this,
Mr. Guru, have you ever considered the policy of the cut and paste method that we use?
my lord, we are before the highest court of the state, my lord.
That is exactly
Exactly, my lord. This undermines the very...
that has been noticed not only in this petition but in numerous.
My lord is very kind, my lord. Very, very kind, my lord. I'll come to the factual aspects, my lord.
Go to the serious point, please.
Now, factual aspects, my lord. Here the bail preferred on behalf of the, my lord, the accused person. He is the main accused, my lord. Main accused, my lord, who had brought the consignment from Dimapur to Meghalaya, my lord. And after compliance with section 50, my lord, these 8 number pouches were, my lord, recovered from his body. So he is the main accused here. Secondly, my lord, this is a charge-sheeted case. The minimal requirement would have been at least he could have enclosed the 161 statements, my lord. What is his stand? His statement before the IO, my lord. That is very crucial for deciding this bail application, my lord. That is not there. Now I am coming to the third, the legal aspect, my lord. In the legal aspect, my lord, though it is an intermediate quantity, irrespective of, my lord, intermediate quantity or commercial quantity, my lord. Time and again, my lord, the apex court as well as this honorable court has taken a stand, my lord, that this is a very serious offence that destroys the very fabric of the society and the future of the, my lord, young generations, my lord. Just, my lord, I had conducted a case before this honorable court, my lord. My lordship had passed a very recent judgment involving similar intermediate quantity, my lord. Okay. This is in case of, my lord, Warshid Uddin Laskar, the order dated 17th of this month only, my lord. Here, my lord, is also an intermediate quantity, my lord. Though the petitioner whose bail was rejected, he was not the main accused, he was the co-accused, he was just the driver, my lord. But here is a case, my lord. The accused person is the main accused from whose body, my lord, the consent was, my lord, recovered. So in view thereof, my lord, I have got a very serious objection, my lord, strong objection to rejecting the bail, my lord.
Just quickly one line, Lordship. I'll just respond to my submission, learned senior. Here, what my the allegation is that the contraband were recovered from the house of the accused person, not from the body, Lordship. Another aspect, Lordship, what my learned senior cited the judgment. That case, why I am saying altogether different. That case, Lordship, the evidence were late, Lordship. One of the witnesses has examination in chief was concluded, and the lawyer could not cross due to some difficulties. And moreover, it was a case of only 9 months, Lordship. 9 months, charges has been framed, and the trial has already started. In fact, one evidence has been laid. Now my case is quite different, Lordship. 1 year going to almost 13 months, Lordship. Now no charges has been framed, no witnesses. So that case and this case altogether different, Lordship. I leave it to my Lordship.
Heard Mr. S. A. Sheikh, learned counsel for the petitioner, who has submitted that the accused person and that the petitioner has referred this instant application for grant of bail on behalf of her husband, Sri Kaisi Kamo, who is an accused in connection with where is the case number?
Case number, Lordship. Now the case has been criminal NDPS case number 4.
Criminal NDPS case number 4
of 2024.
of
2024.
2024 under section 21 under bracket B of the NDPS Act. It is the submission of the learned counsel that the accused person in question, on being arrested in connection with the said case, which was initiated on an FIR dated 9/3/2024, wherein the allegation is that certain quantity of alleged contraband substance, under bracket heroin, was seized from his possession. The quantity being, what is the quantity?
Quantity, Lordship, will find the last page,
92.42
92.42
92.42 grams. Oh, atau pulih yang tu Pak Umar? He has been incarcerated in custody for more than a year. The charge sheet having been filed since the month of September 2024, till date, charges have not yet been framed, and about 15 witnesses, 15 cited, and there are about 15 cited witnesses on the prosecution side to be examined. Next, the learned counsel has maintained that the alleged seizure of the alleged contraband substance being of intermediate quantity. Therefore, the rigors of Section 37 of the NDPS Act would not apply. And as such, the principle of bail and not jail can be applied to the case of the petition of the accused person in question. The Learned Counsel has stressed on the fact that since investigation has been completed, therefore there is no question of the accused tampering with the evidence and witnesses, and because of his prolonged custody in prison as an under trial prisoner, he is therefore, his case may be considered for grant of bail on any condition that is court may deem fit and proper. Per contra, Mr. K. Anything else, Mr. Sheikh? The GA has submitted that, has objected to the prayer made. Firstly, on a very frivolous ground of wrong connotation of the gender of the accused person, as was stated at para 7 of the petition. Again, the GA has objected to the averment made by the petitioner at para 11, wherein the petitioner has averred that that this is the first bail application before this court, and no bail application was rejected by the learned court below or by this court, when in fact by the relevant order, the trial court below had rejected the application of bail made by the accused person in question. Next, as to the reliance of the learned counsel for the petitioner on the fact that bail can be granted since the alleged seizure, since the quantity of the alleged seizure is of intermediate one, and therefore there is no bar for bail to be granted. The GA has referred to a case referred to an order dated 17/3/2025, wherein in a similar case for grant of bail under the NDPS Act for offence under the NDPS Act, this court has rejected the prayer made therein, even though the quantity involved in the said case is also of intermediate quantity. It is therefore prayed that this petition.
No, there is another one, that is a flight risk matter. It is from Nagaland matter.
Is from Nagaland.
Chief,
He is residing with his wife. He is married to the petitioner residing at Nongpo, Lordship.
He is from Nagaland. His wife is from Nagaland.
Any condition, Lordship.
Where is he staying? Nagaland. His wife is
Because
also
his address has been given as Nagaland.
Nagaland.
No, Lordship, because I have not given the address of Nagaland. Lordship.
Anyway, the last objection made by Tilda J is with regard to is that the petitioner, that is that the accused person in question, being a permanent resident of Nagaland, to permanent resident of Nagaland, and as such, if enlarged on bail, there is every possibility that he will abscond. Next. This court is aware of the situation in the state as far as drug related cases are concerned. When time and again newspapers report would flash incidences of apprehension of alleged drug traffickers or peddlers, and also portraying a grim scenario where many, mostly young people are caught in the grip of drug addiction and the like. It is precisely because of such a situation that the police have made several arrests in drug related cases. This state of affair would bring out to the fore two propositions. Firstly, that the prevalence of drug trafficking, peddling, and drug trafficking and peddling in the state is on the rise, which would definitely cause harm to the residents of the state, and as such would cost societal interest to be taken into account. Secondly, the second proposition is that though such drug related cases may be rampant, it does not mean that police can arrest any Tom, Dick or Harry just to project that the situation is grim. It is next. It is a natural preponderance of law that every case has to be looked into on its own facts and circumstances. And more often than not, courts are champions of personal liberty, and as the adage would go, quote, it is better for 99 guilty person to be released than for one innocent person to be convicted. Facts, as indicated by the parties herein and as could be seen from the petition in hand, is that the accused person in question was arrested allegedly on being in conscious possession of certain quantities of alleged contraband substance, under bracket heroin, constituting
92.42
grams, which is of an intermediate quantity. He has been made to stand trial on the IO having found a prima facie case well established against him. He is not the sole accused person in the case, but there are also, how many total? Two.
Three.
But there are also another two co-accused persons in the case. At this juncture, the complicity of the accused person in the case cannot be ruled out. Again, this court would reiterate that while considering the issue of grant or non-grant of bail, certain factors has to be looked into, namely the nature and seriousness of the offence involved, the antecedent of the accused person, and so on and so forth. Given the fact that there is a prima facie evidence against the accused person, irrespective of the length of custody that he is subjected to, this court would also consider the antecedent of the accused person. On perusal of the petition in hand, at page 24 of the same, in the last but one paragraph, there is a noting which says that the accused person, along with the other co-accused person, was also at some point of time arrested in connection with another case. Yes, this is Nagaland case.
This is Meghalaya. Here also.
He was arrested in this Nagaland case?
No, Lordship. In the state of Meghalaya.
No. Look at this. Look at this paragraph 24. Page 24.
Nongpo Lordship.
Nongpo.
Nongpo Lordship, yes.
This case.
Yes, Lordship. No. Other case, Lordship. That Nongpo case number
Nongpo.
18910 of 2022, Lordship.
This case is still going on.
That is it's going on, Lordship.
He was released on bail. That case.
Yes.
Kunum and another case. Nongpo NGP case number 189/10/2022 under section 21B/29 NDPS Act. Then the counsel for the petitioner has admitted that the accused person is also involved in the said case. However, he has been enlarged on bail as far as that case is concerned. Be that as it may, apart from other consideration which the court would not go into in detail, this would reflect the antecedent of the petitioner, of the accused person, which would disqualify him from any relief from this court at this point of time. Petition is devoid of merit, seems disposed of. Seems rejected and disposed of.
On daily list, item number 1.
Well, I pray for 2 weeks' time to file my rejoinder.
All the accused,
All the
respondents
all
have filed
respondents.
their counter.
No. I have filed my affidavit of opposition.
No, have you filed?
Yes, yes.
So all the respondents have filed.
So
How many respondents
One
is
is from Union. No.
Who's for 3 and 4?
I have for 3 and 4.
Only 3 and 4. You have filed. Have you filed?
Just recently, 1, 2, they have already filed. 1 and 2.
1 to 5.
They have already filed. This recently, man.
Mr. Letter Counsel for the petitioner has sought for some time to file the rejoinder to the counter affidavit filed by respondents. We allow this is matter up to 2 weeks.
Oblige.
Item number 2.
Please, Your Lordship. Lordship, both respondents are on board. My friend is appearing for number 1. Number 2, my lord, we have filed an affidavit of service. This was filed on 19th. There are only 2 respondents.
Who is number 2?
Number 2, my lord, is the owner.
Owner.
Yes.
I'm for respondent 1.
Claimant.
Claimant.
Driver?
Driver expired. There's no driver.
So what is your submission?
It can be fixed for hearing, my lord.
A record may be called, Your Lordship, because this is not sufficient. I think so. I'll work.
Yeah, records, Nestle.
Record is here.
Because I've not been called for. This appeal has been admitted. Any condonation application?
No, nothing. No.
Heard Mr. S. General, Letter Counsel for the petitioner, for the appellant who has submitted that the service report on behalf of the respondent on the notice issued upon the respondent number 2 has since been filed. However, such respondent has failed to appear before this court till date. The respondent number 1 is, however, present in court today through Letter Counsel, Mr.
And find my power also.
Mr. General has submitted that since the respondent 2 has failed to appear, this matter may proceed ex parte against him, and the matter may be posted for hearing. Any paperwork required?
No, not required. Because memo of appeal, my lord, is self-contained. It contains everything.
On consideration of such preamble, this court is inclined to allow the same, accordingly, the matter shall proceed ex parte against the respondent number 2. Before the MACT,
Yes, ma'am.
you have taken your defense against on
170.
behalf of yes.
170 defense, my lord. I'll have to check the record because I was not the conducting counsel, but I'll have to confirm this, my lord. This aspect, my lord.
If that is the case, it would have been, it would make your case easier.
Naturally, my lord, naturally. But on a previous occasion also, I had pointed out that in 2016, Supreme Court had clarified that if the insurance company is a party respondent made by the claimant in the MAC proceeding, then 170 is not required, my lord.
Okay.
170 is not, but we'll come to that if the issue arises, my lord.
On. It is the next. It is the further submission of the learned counsel that the appeal has been preferred against the appellant being aggrieved by the judgment and award dated 30/8/2024, passed in MSCT, passed by the learned MSCT Shillong in MSC case number 41 of 2012. Laya? Yeah, boleh. You see, we are all subject to authority.
Absolutely. All of us.
Nobody is high, nobody is low. However high you may be, you are still below the authority. And finally, every one of us is under this sovereign.
True.
What to do? By the way, what about the other matters? Any matter that is ready for hearing? I'll pass this orders, Mr. Jinder. I'll pass this orders.
Item number 3, Your Lordship, we have taken the steps for, we have already effected the service to respondent number 1 by publication of the paper, and to that effect we have also filed the
I'll
evidence.
pass this orders.
And the
respondent number 3 is concerned, I am appearing, my lord. I have the instruction to appear.
In which case?
Item number 3, my lord.
3, okay. You will appear.
I'll be appearing, my lord. We have the instruction.
Fine. So, sir, we'll note down your name and
matter may be fixed for hearing because everything is complete now.
Complete?
Yes.
It may be fixed, my lord, the last week of April, preferably on 28th.
I have no problem.
Around 28th.
28 April.
4 weeks. Tomorrow, 4 weeks.
Can your lordship like to fix a date?
It depends on you. If you want to fix the date.
28.
28. What is
Lordship.
28? Monday.
Lordship, 28 I am having some problem, Lordship. So it can be
29.
29?
Any Monday.
Then any Monday other than 28.
21st.
21st. Then, Mr. General, you come alone. 21st, I'll be at home.
Oh, 21st.
Monday's a holiday, 21st.
30th or Monday?
5th would be the most. 5th of May.
Lord, any Monday is preferable for me because I can say.
Okay, let's go. Let's go to the Monday after 28th.
All right.
All right.
The 5th.
5th.
Yeah. 5th of May.
5th May. What about 4?
Obliged.
Please, Your Lordship, we will be filing our affidavit during the course of the day, Your Lordship.
Stop more to me. You are for respondent?
For petitioner, Your Lordship.
Then why would you file an affidavit?
Now we have we will file additional affidavit and now to bring on record on 6-1 statement.
After 2 weeks, Your Lordship.
2 weeks. The other matters will be posted to the next day.
There is an item 7. If this matter
Item 7 I am there also.
can be taken up some other day, Your Lordship.
Yes.
I think Mr. Paulso is not available today.
2 weeks.
2 weeks. Your Lordship.
All the other matters, 2 weeks.
Obliged, Your Lordship.
Item number 6, Lordship. The opportunity
Court has already said other matter
because they have not
after
filed the affidavit till now.
Because of paucity of time.
Also.
1 week.
Obliged, Your Lordship.
6 thought.
My lord, I have the record with me. I've received it.
Produce it.
They're supposed to file an affidavit, additional affidavit. Lordship. There is a direction, Lordship, in the
You
order.
give it to the court master and I'll pass the orders.
Then
Or if the matter is to be heard, then we'll take it up on
Lordship
Monday.
has heard the matter several occasions, Lordship.
We'll take it up on Tuesday.
Tuesday, my lord.
Tuesday. So Tuesday. Go to
So, my lord, I may be just be allowed to produce instead of filing or whatever.
produce. Yes.
Yes.
Done.
Yes, my lord.
So,